Hello, everyone. This is Clint Macro, Vice President of Firearms Owners Against Crime Institute for Legal, Legislative, and Educational Action. FOAC ILLEA, or FOAC Institute, as it's known as, is Pennsylvania's preeminent Second Amendment organization that is pro-gun and anti-crime. And unfortunately, a lot of the crime we fight is elected officials who can't follow the law. And that's exactly why we're here today. We've recently had a tremendous success in the court system, and our president, Jim Stoker, and our attorney, Joshua Prince, are here to fill you in a little bit more about the win we've had with FOAC, Grant Schmidt, Shot Tech LLC versus Lower Merion Township. So, fellas, thanks for joining us here today, and thank everyone for tuning in. Let's talk a little bit more about this win.
Yeah, I'd like to take a couple minutes to thank Josh. Josh, thanks for taking the time to join Clint and I here today. We just wanted to have a brief conversation with you, maybe a 10-minute rundown of why this case is so important and why it matters so much in Pennsylvania. So obviously, you're our chief counsel. You're who we rely on for this type of thing, and you, again, knocked it out of the park. So if you would, just in layman terms for us, remember, a lot of folks we talk to are not attorneys. And I'll be honest with you, sometimes you talk me in circles on it, even though I'm with you all the time. But if you could explain to everybody why this case against Lower Merion was so important, we'd appreciate it.
Sure, and that's very kind of you to say, Jim. My head is so big, I'm not sure it's going to fit in the Zoom window. But anyway, so yeah, yesterday we were successful before the Commonwealth Court. For those who don't know, the Commonwealth Court is one of our general and intermediate appellate courts. Sometimes it does act as a trial court, one of the only courts in the nation that acts both as a trial and appellate court, but we were before it in its appellate capacity because back in 23, Lower Merion Township passed an ordinance that regulated the location and other things of federal firearms licensees, so your gun dealers. They included all sorts of restrictions, including conditional use, meaning that you could only be in a very specific zoning district, but even being in that zoning district, you still needed to meet their conditions. And those conditions weren't always extremely clear. They included some things such as having shatterproof windows and doors, also had to have a safety basic strategy, even though they didn't define what exactly that was supposed to be. Beyond all those things, they had inclusions for alarm systems and requiring certain data to be provided to Lower Merion Township. And so we did file suit. And initially, in front of the Montgomery County Court of Common Pleas, we got, of those approximate 13 different requirements, 10 knocked out through a permanent injunction. At that point, because there was still the conditional use requirements and other requirements such as having to supply a copy of your federal firearms license to Lower Merion Township, which is a safety concern in and of itself, because there are a whole host of issues of whether that's disclosable through a right to know law request, whether someone might use that federal firearms license copy for nefarious purposes, as well as having to provide fictitious names and addresses, all sorts of stuff that they decided to require. And so we were litigating the case in front of the Commonwealth Court. The court decided to hear it en banc. And what that means is that the court, instead of in just a three-judge panel, decided to hear it in front of the entire court. That is the strongest type of decision that one can get out of an appellate court because it is in front of the entire court. And also the court, in order to even consider overturning any prior precedent it's issued that's at least binding precedent, would have to meet together en banc to overturn it. And so after we briefed everything and basically submitted it in, the court decided it wanted oral argument. Oral argument went very well for us. And then after that, yesterday, as I said, we got our decision. The Commonwealth Court found that the Montgomery County Court of Common Pleas, in issuing its initial injunction, was correct with those 10, but incorrect that it didn't enjoin the remaining 3, and that the entirety, as we argued, of the ordinance was preempted under our state preemption statute, which is Section 6120. Now, we had made a plethora of other arguments. We had argued for something called field preemption, which in layman's terms basically means even if the express statute of this express preemption provision does not prevent a municipality from doing this because of the breadth of the regulation that the General Assembly has issued regarding guns, gun rights, yada, yada, that they had intended to preempt the entire field. The Commonwealth Court, because of the fact that one of its prior decisions that we were not involved in is currently up on appeal before the Pennsylvania Supreme Court regarding whether there is actually field preemption in addition to express preemption, declined to address that issue. And I understand why they did that, because they don't want to have one en banc decision that's up on appeal by Gun Owners of America because they had lost before the Commonwealth Court, and now issue a new decision that's contrary to that decision that's up on appeal. And quite honestly, for those who are aware, there are several cases that we have up on appeal that the Pennsylvania Supreme Court has decided to stay pending its decision in that GOA case. And why that's important is our cases. So one was City of Pittsburgh that FOAC handled and represented those individuals. We were successful in getting all three ordinances knocked out. Some of you may remember that NRA had sued, but only over one portion of one of the ordinances. We actually sued over all three in toto, and the Commonwealth Court issued its ruling in our case saying that, yeah, all three are completely preempted, so there's no need for us to really even consider the NRA limited challenge case. That case is up on appeal by the City of Pittsburgh before the Pennsylvania Supreme Court, and it has now stayed that decision because, believe it or not, I believe it was 2019 when we instituted litigation against the City of Pittsburgh over those ordinances. And it has taken all this time. I believe this is now the second stay because initially the Pennsylvania Supreme Court had stayed it pending its decision in Crawford, where the City of Philadelphia had challenged whether constitutionally the General Assembly could restrict a local municipality's right to regulate firearms and ammunition. And of course, my dogs decide that right now is a good time to drink. So anyway, that case, like I said, has now been stayed a second time because of the GOA case. And what's interesting to me is I think there is a reason that the court took up the GOA case versus the Pittsburgh case. We also have the Armstrong case that's up pending on stay before the Supreme Court that involves the City of Philadelphia prosecuting someone civilly for not disclosing lost theft of a firearm. At least that's what they allege. But it's interesting when you actually read what they truly allege, that that's not the case. And their ordinance that they're trying to utilize was actually previously enjoined. So they're trying to stretch their ordinance and the law to benefit them. But nevertheless, those two cases are up there and stayed. And I think the reason why the Pennsylvania Supreme Court decided to stay those two and hear the GOA case is because it arguably involves a much broader issue. It involves partially manufactured frames or receivers. I really wish I had been involved in that case because the Commonwealth Court got it wrong in that time. It's one of the few times our Commonwealth Court has gotten a preemption case wrong. It was an en banc decision, as I mentioned before, where they said that because partially manufactured frames and receivers weren't yet firearms, the City of Philadelphia could regulate them. Yet how they regulate them is as firearms. So how is it that it doesn't come under the guise of our preemption statute? But as I said, we've filed an amicus brief in that case. That case has been fully briefed. Interestingly, oral argument hasn't yet been scheduled in that, which is a little bit unusual given the fact that briefing's been done for several months now. So I'm not sure what to make of that. Generally speaking, from my experience litigating before the Pennsylvania Supreme Court, somewhere around 2 to 3 months after briefing is complete, you get an oral argument notice. So is this an instance where the court may decide to decide this case without oral argument? It's a possibility. It would be very rare for the court to do that. But nevertheless, getting back to our case before the Commonwealth Court, this case again involved the regulation of federal firearms licensees in locations within Lower Merion Township, and the court correctly found that all of these types of ordinances were preempted expressly under 6120. set aside for another day whether field preemption may exist. We also did not address our arguments under Article 1, Section 21 of the Pennsylvania Constitution of whether these types of ordinances would be preempted by it itself. So that's kind of the background. I know everyone is ecstatic about this decision. I tend to be brought in on the cases where everyone says they are very difficult, if not impossible, to win, because I have a pretty good success rate of winning those cases. And I'm very proud of that. And I've earned a lot of discretion by the Commonwealth Court because they know if I'm coming in with an issue, I'm going to back it up legally and that there is a basis in the law for what I'm arguing. So very thankful to have this opportunity to litigate these important issues. If it wasn't for FOAC Institute, we wouldn't be able to bring these types of matters. In fact, there are so many preemption violations across the Commonwealth, and we really do strive to try and get municipalities just to simply comply with the law, because something no one wants to talk about is the fact that under the Uniform Firearms Act, if you look at Section 6119, it says that any violation of the Uniform Firearms Act that is not otherwise graded is a misdemeanor of the first degree. So when local municipalities and their members actively violate Section 6120, it's a misdemeanor of the first degree. We need district attorneys to get out there and start prosecuting this, because that is the stick that comes along with the preemption statute. And because that stick is not being utilized, and the only stick being utilized is FOAC Institute bringing these types of cases, which, oh yeah, by the way, harms the taxpayers. Because guess who ends up paying for all the litigation in that? It's the taxpayers. I really truly hope at the next meeting in Lower Merion Township that the taxpayers come out and demand answers from the Board of Supervisors, their elected officials who have continually decided. Because if we look at it, this is not the first case FOAC Institute has been involved in involving Lower Merion Township. We've been successful several times with them. But getting back to what I was saying before, it isn't always just about suing. We always take the proper approach, at least in my opinion. We send a notice to the municipality, their general, what's called solicitor, which is the attorney for that local municipality, saying, look, you're in violation of the law here. We all just want compliance with the law. Now, let me ask you this. When's the last time you were violating the law and someone sent you a nice letter saying, hey, look, please just don't do this again? Usually that doesn't happen. What you get is, fingerprint order in the mail. Jim can talk to this.
Yeah.
Or maybe you get cuffs slapped on you right away because it's a felony. But we always try to do the right thing and ask them just simply, look, we understand the law is complex. No one here is disputing that. We understand your solicitor may not be up to speed on these types of issues. You may not even know anything about them. Just please correct this injustice. And where they agree to, that's it. You probably never hear anything about. I can't count the countless letters I've sent on behalf of FOAC, and I know, Jim, you've sent your own letters on behalf of FOAC to municipalities just saying, hey, look, please change this. They do it. You never hear anything about it. But it's these cases where they generally tell us to go pound sand that we then have no other choice but to bring lawsuits. And there are several other lawsuits currently pending regarding preemption. And Jim, I don't know if you want to touch on those at all, just to let the membership and other viewers know why it's so important to donate to FOAC Institute, because the membership, annual or even lifetime rates don't cover this type of litigation, unfortunately. And FOAC Institute really needs your support to be able to continue on with these types of challenges. So with that, I'll give it back to you, Jim. I know as a lawyer, I talk a lot, and it's hard to get a microphone away from a lawyer.
That's why we brought you here. You bring up some very valid points. So like you said, we have several other lawsuits where it's death by a thousand cuts. We use that term quite a bit, right? Where they understand it costs us money to bring these lawsuits, and they're fighting us with tax money. So they don't feel, if their constituents in their districts don't show up to object to them spending their tax money that way, they're writing the check on somebody else's dime. So we know that's a big issue. We're trying a couple of these cases. If I remember right, you and I have had that discussion where, we're trying to make sure that we can get legal fees back out of them, but that's a very steep hill to climb. We don't know if that's going to be successful yet or not. Clint and I were just with the Attorney General a couple of weeks ago to talk about the enforcement of the preemption statute and how that's impossible because the district attorneys just don't want to get wet in the politics. So they're avoiding filing charges against their own city councils or county commissioners. And so that we're kind of left in limbo where we have to pay to fight our own tax money in many of these districts. So yeah, I agree 100%. It's a cloudy issue out there. And yeah, we do need donations to keep these kinds of cases going. We know we have dozens, if not over 100 different municipalities at some level of violation. And we just can't afford to go and fight them all. So that's a very valid point you bring. I think what's important for folks to understand here, and correct me if I'm wrong, but we've seen a couple cases now where they've tried to use zoning law to restrict people's Second Amendment rights. And that's what makes this such a, in my opinion, almost a landmark issue in Pennsylvania, is it's basically the first time we have a higher court telling a municipality, you may not use zoning law to restrict someone's Second Amendment rights. And this could go a long way for us in dealing with, if they'd gotten away with it, you would see all the municipalities that are out there that want discharge ordinances, that want prohibitions on carry, that want to be able to restrict your Second Amendment right, simply turning to zoning law and stating that it's outside of preemption. So to me, that was a massive win for us, and I can't thank you enough for your time. I know, sitting in the courtroom and watching you, you almost have to tap dance a little bit around the previous court case because you're basically telling the Commonwealth Court, hey, you got it wrong in the past. And you're doing that to the people that are about to put judgment on your
And,
on your
and
brief.
you probably remember that because one of the cases that's even discussed in the decision is the gun range case out of Philadelphia,
Yeah.
where Judge McCullough, who I am the first to say she is the largest ardent defender of our constitutional rights on the Commonwealth Court. There is none better, none braver than Judge McCullough. But she had actually issued that prior decision that said that the city of Philadelphia could regulate through by right certain zoning districts. And she was on this panel, and I argued before her that she actually got it wrong. Now, there is a way in which you have to do that. There is an art to it, but I gave her all the ways to get out of it because the case law wasn't the same back then. We have new case law that some would say has expanded. I will say just really recognized what has always existed when it comes to preemption. There was also differences that were between the gun range case, this case, as well as arguments. In the gun range case, they never raised a field preemption case argument, excuse me. The other thing that's interesting is the gun range case that everyone wants to rely on was non-precedential, meaning it was not a published decision. And generally speaking, for lay people who have no knowledge, and in fact, probably there's plenty of attorneys that don't know this, the reason why a court tends to issue a non-precedential decision is because the arguments put before it may not be fully addressed. There may be things that the court thinks should be addressed before it issues a binding decision on the issue. And so during oral argument, this came up. Why isn't gun range, precedential? It was issued as a non-precedential decision. And I was able to articulate to Commonwealth Court Judge Wojcik that there are reasons why the court issues a non-precedential decision, and it's because the court doesn't want to be bound by it because the court may feel there are arguments that haven't been properly raised or brought before it.
And that's it right there. So you're being politically correct about it. But the simple fact is, if in the gun range case, they had hired you to represent the Second Amendment interest in that case, you would have taken preemption to it, and that case would have come out completely different. That's my belief. That's why we use you as our chief counsel. I think that the attorney in the other case screwed up by missing that opportunity, and I believe the Commonwealth Court recognized that that challenge was yet to be laid out there. and therefore it was not precedential. I would agree with you on that.
Well, that's very kind of you to say, and I have been very blessed to have a very fortunate career before the Commonwealth Court. I love practicing before that court. It is a phenomenal court. But where I do want to go with this, because I know we're probably close to out of time, if not over already, I think it's important to mention to all the viewers the city of Harrisburg case, because we are now, for the second time, up on appeal in that case. And for the viewers who don't know, we went all the way up to the Pennsylvania Supreme Court, established brand new precedent that was never established here in Pennsylvania before regarding the Declaratory Judgment Act and what needs to be put in a complaint to establish standing when you're challenging an unlawful, or what you can contend to be an unlawful ordinance. We now went back to the trial court. The trial court enjoined the majority, all but one of the ordinances we were challenging in Harrisburg. And now we're up on appeal. The city of Harrisburg originally appealed the determination enjoining the majority of their ordinances and then decided to withdraw it because they knew they weren't going to win. The only one issue that's currently up before the court is the city of Harrisburg's state of emergency provision, which, interestingly enough, the state of emergency provision, the statute at the state level, has already been ruled unconstitutional under Second Amendment grounds. And I know that because I was the attorney involved in that. But what's interesting is that the city is still fighting that it should be able to restrict people's rights during a state of emergency, the time at which you most need your rights. And so we just got notice this past week that the court wants oral argument. And again, I know a lot of the listeners don't know much about the Commonwealth Court. With the Commonwealth Court, you only get oral argument if they want it. Most attorneys will tell you they've practiced their entire career. If they go up in front of the Commonwealth Court, they've probably never had oral argument. Every single one of my cases ends up with oral argument in front of the Commonwealth Court, whether it's a panel decision or en banc. But we got notice the week of December 8th, they are tentatively going to be scheduling oral argument in the city of Harrisburg case, and I expect to win that one as well.
We've been there a lot. Yeah, absolutely. So thanks for your time. I think it's important, what you said. We can't do this without donations. So folks, if you're watching this and you want to be engaged in this fight, you want to help us win these battles with Josh, a little bit of help goes a long way. Go to www.2apa.org, click the members tab and click donate and give what you can towards these cases. We call it our war chest, and that money is used to fund all these types of litigation. Clint, you've got anything you'd like to add for us?
I'd just like to thank everyone for tuning in. Jim, I want to thank you for your leadership in the organization. And Josh, I want to thank you for your wisdom and leadership with our legal endeavors and in the court.
And I just want to end with one thing.
Pennsylvania owe you both a great deal of gratitude.
Well, that's very kind, but I want to end with one thing because I really want anyone who watches this video to know one thing. No one in the FOAC Institute gets a salary. Think about that. Every single cent you give to FOAC Institute goes to these types of matters. Unlike other organizations where their CEOs, their presidents are making hundreds of thousands, millions of dollars a year, that isn't the case with FOAC. So if you want the best bang for your buck and success rate, there is no question, donate to FOAC Institute.
Great. Thank you, sir.
Harumph. Thank you very much, gentlemen.
All right, everybody, stay safe. Make sure you look us up, and we'll keep fighting. Appreciate you.